of opposition to Judge Kavanaugh's nomination. These are letters from Lambda Legal and 63 national, state, and local LGBT groups, from Earth Justice, from Muslim advocates, from 63 women lawyers and supporters of whole women's health, from Secular Coalition for America, and from Asia Pacific American advocates. I ask unanimous consent to enter these letters into the record.
Without objection.
Thank you. Judge Kavanaugh, Chief Justice John Roberts has recognized that, quote, the judicial branch is not immune, end quote, from the widespread problem of sexual harassment and assault, and has taken steps to address this issue. As part of my responsibility as a member of this committee to ensure the fitness of nominees for a lifetime appointment to the federal bench, I ask each nominee 2 questions. First question for you. Since you became a legal adult, have you ever made unwanted requests for sexual favors or committed any verbal or physical harassment or assault of a sexual nature?
No.
Have you ever faced discipline or entered into a settlement related to this kind of conduct?
No.
I started asking these questions about sexual harassment because it's so hard to hold lifetime appointees to the federal bench accountable, and because I did not want the Me Too movement to be swept under the rug. While Senator Hatch asked you some questions about this, I have some additional questions for you. Last December, 15 brave women came forward and shared their stories of sexual harassment and assault by former Judge Alex Kozinski. Some of them are detailed on the chart behind me. Very explicit allegations of sexual harassment and assault. We know from the reporting that Judge Kozinski's behavior was egregious and pervasive. It went on for more than 30 years. It affected law clerks, professors, law students, lawyers, and in at least one case, even another federal judge. And those are just the women who came forward. Judge Kozinski's behavior became so notorious that professors began to warn female students not to apply for clerkships with them. Judge Kozinski's behavior in this regard was an open secret. A short time after Judge Kozinski's accusers went public, the judge abruptly resigned, which effectively shut down the federal investigation into his misconduct. I do not think this was a coincidence. In 2008, in connection with another investigation into Judge Kozinski, the LA Times wrote a story about something called the Easy Rider Gag List, an email group that the judge used to send what the Times reported was, quote, a steady diet of tasteless humor, end quote. The report describes the list as made up of friends and associates, including his law clerks, colleagues on the federal bench, prominent attorneys, and journalists. Senator Hatch asked you if you were on this Easy Rider gag list, where Judge Kozinski would send inappropriate materials. Your response was that you don't remember anything like that. Are you telling us that you may have received a steady diet of what people on the list have described as, quote, a lot of vulgar jokes, very dirty jokes, but you don't remember it?
No, I don't remember anything like that, and I'm not.
Oh, the answer is no. Have you ever?
If I could elaborate.
I think that's a complete answer. Let me go on. Have you otherwise ever received sexually suggestive or explicit emails from Judge Kozinski, even if you don't remember whether you were on this gag list or not?
So, Senator, let me start with no woman should be subjected to sexual harassment in the workplace. And
Judge Kavanaugh, you already went through all of that, and I will get to your perspective about making sure that women in the judiciary do not get sexual harassed. I just want to ask you, during and after your clerkship with Judge Kozinski, did you ever witness or hear of allegations of any inappropriate behavior or conduct that could be described as sexual harassment by Judge Kozinski?
No, Senator, and there were 10. I worked in Washington D.C. There were 10 judges in the courthouse with him in Pasadena. Prominent federal judges in the courthouse with him, and we worked side by side with him day after day while he was chief judge of the Ninth Circuit.
To be clear, while this kind of behavior on the part of Judge Kozinski was going on for 30 years, it was an open secret. You saw nothing, you heard nothing, and you obviously said nothing. Judge Kavanaugh, do you believe the women who recently came forward to accuse Judge Kozinski of this kind of behavior?
I have no reason not to believe him, Senator.
So, let me just put this into a context, because you have testified that you basically saw no evidence of this kind of behavior at all. You never heard of it, but you worked closely with him on a number of projects. It wasn't just during the time you were clerking for him. You kept in touch with him while you were in the White House. He introduced you to the Senate at your 2006 nomination hearing, and he called you his good friend. Yesterday, you called each of the people who introduced you a friend, and I presume you felt that way about Judge Kozinski when he introduced you in 2006. You joined him for panels at the Federalist Society, where you patted him on the shoulder and said, "I learned from the master about hiring clerks." And I believe I have a photo of that. Here's Judge Kozinski. You told us that you have hired many women clerks, how you are a mentor to women, how important you think it is for women to have a safe working environment where they feel that they can report sexual harassment. I conclude that you consider yourself an advocate for women. If a judge was aware that another judge was engaging in sexual harassment or sexual assault, would the judge have a duty to report it?
Had I heard those allegations, Senator, I would have done three things immediately. I would have called Judge Tom Griffith, who's on our court, who's on the Codes of Conduct Committee for the Federal Judiciary appointed by Chief Justice Roberts. I would have called Chief Judge Garland, who's chair of the Executive Committee. I would have called Jim Duff, who's head of the Administrative Office of the U.S. Courts. If for any reason I was not satisfied with that, I would have called Chief Justice Roberts directly.
So you believe that all judges who, including yourself, if you ever heard or any allegations about these kinds of behaviors, you would report it, you would go through whatever processes were set up by the courts to prevent this kind of behavior and to hold people accountable. And yet, someone that you've been close to, that you clerked, and I did go through the various encounters, more than encounters, that you had with Judge Kozinski, and yet you heard nothing, saw nothing, and obviously you did not say anything. So let me just mention that this is why the Me Too movement is so important, because often in these kinds of situations where there are power issues involved, as certainly there are between judges and clerks, that often it's an environment where people see nothing, hear nothing, say nothing. And that's what we have to change.
I agree with you, Senator. I agree completely. There need to be better reporting mechanisms. Women who are the victims of sexual harassment need to know who they can call, when they can call. They need to know first that the way
Judge Kavanaugh, perhaps if all of those situations or those processes had been in place over the 30 years that Judge Kozinski was engaging in this kind of behavior, maybe he would have stopped, but he did not. I have one more question, Judge Kavanaugh. Were you aware of the serious allegations of domestic violence against Rob Porter before you recommended him for staff secretary to Donald Trump?
There's a premise in there that I'm not sure is accurate.
The premise being that he engaged in domestic abuse?
No, the recommendation premise. But put that aside. No, I was not aware of those allegations until they became public, when there was the news reports about them.
Let me turn to another set of questions that I have for you. In 1999, you joined Robert Bork in writing an amicus brief in support of Harold Freddie Rice, who challenged the voting structure for Hawaii's Office of Hawaiian Affairs, a state office charged with working for the betterment of Native Hawaiians. Yes, sir. You argued that Hawaii could not limit those who voted for the office as trustees to only Native Hawaiians. You not only made this argument in a legal brief, but you also published an opinion piece in the Wall Street Journal under your own name entitled, quote, "Are Hawaiians Indians?" In the piece you wrote, the Native Hawaiian community was not indigenous because, as you said, after all, they came from Polynesia. It might interest you to know that Hawaii is part of Polynesia, so it's not that they came from Polynesia, they were part of Polynesia. Hawaii is part of Polynesia. Native Hawaiians did not come from Polynesia. Let me repeat that. They were part of Polynesia. You also implied that Native Hawaiians couldn't qualify as an Indian tribe and therefore were not entitled to constitutional protections given to indigenous Americans because, and I quote you, they don't have their own government, they don't have their own elected leaders, they don't live on reservations or in territorial enclaves, they don't even live together in Hawaii. Let me tell you why each of these assertions are wrong, but it is the basis on which you determine that the OHA elections were unconstitutional.
Well, the Supreme Court agreed, though. The Supreme Court agreed 7-2.
They did not agree based on necessarily your arguments. Let me go on. To say that there is no system of law is an insult to the society that evolved in the Hawaiian Islands over centuries, even before the creation of the United States. To say they don't have their own elected leaders in a historical sense just betrays, in my view, your ignorance of Native Hawaiians. They were a self-sustaining, self-governing society for 1,000 years prior to the so-called discovery by Captain Cook. You said they don't live on reservations or in territorial enclaves. They don't even live together in Hawaii. You know, it's hard to know what to say to this assertion. It sounds like you're saying that Native groups in the United States derive their rights from having been herded into reservations and cheated out of their land, or that they surrendered their rights when they move outside of these artificial boundaries. It is not only factually wrong, but also very offensive. Judge Kavanaugh, it is hard to believe that you spent any time researching the history of Native Hawaiians. Now, I'm going to refer to an email that you
May I respond to that?
Sent out. I'm going to get to my question.
Okay. Thank you.
You sent out an email on June 4th, 2002, and I want to read in part. Any programs targeting Native Hawaiians as a group is subject to strict scrutiny and of questionable validity under the Constitution. Now, you sent out this email after the Rice decision had already been made by the Supreme Court. When you wrote this email saying that all Native Hawaiian programs should be undergo strict scrutiny because there are questionable validity under the Constitution, were you looking to Rice v. Cayetano as a basis for this view, which you expressed in your email?
So, Senator, first of all, appreciate your perspective. The amicus brief I wrote was the Supreme Court agreed with by a 7-2 decision written by Justice Kennedy in that case, Rice versus Cayetano. And that decision in the case, just so I'm clear, it was a state office that denied African Americans the ability to vote for that state office. Latinos and other people were denied the ability to vote for a state office. And the question was whether that was permissible under the Constitution, and the Supreme Court by 7-2.
Yeah, Judge
that was,
I attended that Supreme Court hearing.
Mm-hmm. I did
and
too.
I believe that one of the reasons they kept asking about trying to figure out whether Native Hawaiians constitute tribes is probably because of the amicus that you put in there that raised this issue. So let me go on. You know, you didn't answer my question as to whether or not when you said that any program targeting Native Hawaiians as a group is subject to strict scrutiny and of questionable validity under the Constitution. My question to you was, were you thinking about the Rice decision, which you continue to say, yes, the Supreme Court agree with you. Were you thinking about the Rice decision when you made this view known?
That's an email 16 years ago. I don't recall what I was thinking about when I wrote it.
It was right after the Rice decision. This is a 2002 email. The Rice decision was 2000. Well, let me ask you this then. Do you think Rice v. Cayetano raises constitutional questions when Congress, not the state, because Rice was a state action case. It had to do with the 15th Amendment, not the 14th Amendment. It had 15th Amendment having to do with voting rights. So my question to you is, do you think Rice v. Cayetano raises constitutional questions when Congress passes laws to benefit Native Hawaiians?
I think Congress's power with respect to an issue like that is substantial. I don't want to pre-commit to any particular program, but I understand that Congress has substantial power with respect to declaring, recognizing tribes
But you believe that any of these kinds of programs or laws passed by Congress should undergo strict scrutiny and raises constitutional questions?
As I sit here today as a judge, I would listen to arguments that 16 years ago, and I'm working in the administration and the executive branch and putting forth the position there. But if I were a judge, I would listen to the arguments. To your question, Congress has substantial power with respect to programs like this. I appreciate what you've said about Native Hawaiians. The specific case was about an election to a state office.
Yes, that's why it's a state action case. I am well aware of the basis on which the Supreme Court made that decision. So, Judge Kavanaugh, Rice is often cited for the proposition that laws that benefit Native Hawaiians are unconstitutional because they are race-based. Do you think Rice can be cited for that view, knowing, as you have acknowledged, that it is a state action 15th Amendment voting rights case? Rice, I know this, Rice is often cited for the proposition that all Native Hawaiian programs enacted by Congress can be challenged as unconstitutional as race-based. I'm asking you if that is an appropriate citation of the Rice decision.
Senator, I think Congress has substantial power, of course, in this area that you're discussing. And I would want to hear more about how Rice applies. I would want to hear the arguments on both sides. I would keep an open mind and appreciate your perspective on this question.
You know, when the Supreme Court keeps an open mind and listens to the litigants and the advocates, one would hope that the advocates will actually proffer facts to the court, and that is not what you did when you filed your amicus to the court. And I think you have a problem here. Your view is that Native Hawaiians don't deserve protections as indigenous people under the Constitution. And your argument raises a serious question about how you would rule on the constitutionality of programs benefiting Alaska Natives. I think that my colleagues from Alaska should be deeply troubled by your views. And I know that in your amicus brief and in your Wall Street article, you did not mention one word about Alaska Natives. And it could be because there is no Commerce Clause reference to Alaska Natives as there is for American Indian tribes. I want to go on to another set of questions because I am running out of time. I want to follow up on your discussion with Senators Feinstein about Roe v. Casey and your conversation with Senator Durbin about Garza, and also raised by my colleague, Senator Blumenthal. You talked about the importance of precedents. You said you understand the strong feelings about abortion. You said you recognize the real-world effect of cases and you don't live in a bubble. But I think when you talk about respect for precedent, it's misleading because there are ways to say you are relying on precedent, i.e. Roe and Roe v. Wade and his progeny, but still severely limit a woman's right to make her own reproductive choices. And that is exactly what you did in Garza. Because we all recognize that even if Roe v. Wade is not overturned, there are going to be many cases that will continue to come before all of the courts, including the Supreme Court, that will probably be laws enacted by states that will limit a woman's right to choose. So, including things like parental consent, spousal consent or notification, limits on where abortions can be performed, i.e. whole women. So both Senators Durbin and Blumenthal explained the facts in Garza, so I won't go over that, but when the case reached you, you took any opportunity you could to prevent that girl from getting an abortion. You said you were relying on precedent, but you weren't. You turned this case into a parental consent case, which it wasn't. Then you looked at the facts and ruled against, in my view, all common sense, that keeping a young woman behind lock and key against her will by ORR, Office of Refugee Relocation, insisting that ORR be allowed to delay beyond the time abortion would no longer be feasible by finding her sponsors that she did not need, and that you deemed these factual circumstances not an undue burden on her constitutional right for an abortion. Let me read you a portion of your dissent in this case. You say the majority points out in states such as Texas the minor will have received a judicial bypass. That is true, but is irrelevant to the current situation. Why? The current situation was all about parental consent and the need to get judicial bypass, which this young woman did. So if there's anything that's irrelevant, is your argument that this was a parental consent case. Then you went on to analyze this case on the basis of whether or not keeping her under lock and key, insisting that there be sponsors found for her, which could have ended up being an unfeasible time frame for her to get an abortion, and you deemed those not to be undue burdens. The young woman had already received a state judicial bypass, as referenced before. The fact that she did not have, you thought that parental consent, and that was not even an issue. It was irrelevant. So this is very disturbing. Is it any wonder there are so many people who, even if you are not sitting there, in spite of the fact that President Trump said his nominees to the Supreme Court will overturn Roe v. Wade, even if Roe is not overturned, there will be, as I mentioned, all of these cases that will put barriers before a woman's right to choose. So I find it really a rather unbelievable. And by the way, you also mentioned, you said several times that in Garza, you did not join the dissent, which basically says an alien minor does not have a constitutional right to an abortion. So does the fact that you didn't join this dissent mean that undocumented persons do have a constitutional right to an abortion?
Well, I decided that case based on the precedent of the Supreme Court and the arguments that were presented in the case. I made clear that I was following as carefully as I could the precedent. You mentioned parental consent and spousal consent. Just the Supreme Court has upheld parental consent laws, but has rejected spousal consent.
Usually it requires a judicial waiver, which was the case in the Texas case. You can't just require parental consent, as in this case where parents were beating her up. How can you expect parental consent in a situation like that?
That would be a situation for the bypass. This was an analogy for a woman who was a minor, that's critical, who was in an immigration facility by herself in the United States and had...
She had already gotten a judicial bypass. There was no issue of parental consent, and in this case you would have substituted a foster family for parental consent. That's not even an issue. But I do have a question, since you mentioned several times that you did not join the dissent, and the crux of the dissent was that there was no constitutional right for an alien minor to have an abortion. I want to ask you, did you join or did you not join that consent because you disagree with that in fact, alien minors do have a right to an abortion in our country?
Well, so as a general proposition, well, first of all, the government did not argue in that case that aliens lack constitutional right generally to obtain an abortion.
Yeah, even they didn't argue it because probably they figured that that is a decided issue, but maybe you don't think so. Do you think that that is an open question as to whether or not alien minors or, in fact, aliens in our country have a constitutional right to an abortion? Do you think that is an open case?
The Supreme Court has recognized that persons in the United States have constitutional rights.
Okay. So I hope that's why you didn't join the dissent. Moving on to another set of questions. Relating to your dissents, I think you can learn a lot about a judge by looking at his or her dissents. And that's why judges go out of their way to voice their disagreement with the majority and show what their views are. And you have the highest dissent rate among active D.C. Circuit judges, 5.1 dissents per year. I'm going to talk about several studies that analyze your decision. The first study by Professor Elliot Nash and Professor Daniel Chen shows that compared to other circuit court judges elevated to the Supreme Court since the 1980s, you not only had the highest rate of dissents, you also had the highest rate of partisan dissents. So I think I have a chart on that. Well, maybe not. Suffice to say, there is such a study, and I ask unanimous consent to have the study by Professors Ash and Chen be entered into the record. The second study by people, thank you. I'm on a roll here, Mr. Chairman. The second study by People for the American Way shows that you consistently sided against workers or immigrants and only once favored consumers in your dissents. Mr. Chairman, I ask unanimous consent to have the People for the American Way study entered into the record.
Without objection.
A third study by Public Citizen shows that in cases where there was disagreement among the judges, you consistently sided against helping people who wanted to protect our clean air and water. Mr. Chairman, I ask unanimous consent to have the Public Citizen study entered into the record as well.
Without objection.
A fourth study, a detailed study by Professors Cope and Fishman, found that you are, and I quote their study, no judicial moderate, and that, quote, it's hard to find a federal judge more conservative than Brett Kavanaugh. Mr. Chairman, I ask unanimous consent to have the study of Professors Cope and Fishman entered into the record as well.
Without objection.
Judge Kavanaugh, why do you rarely dissent on behalf of consumers, workers, or the powerless? And please, don't talk to me about all the times that you were with the majority or where you joined other majorities.
Well, Senator, I've ruled for workers many times. I've ruled for environmental interests many times in big cases that involve clean air regulation, particulate matter regulation, affirmative defense for accidental emissions, the California Clean Air Law over a dissent by a fellow judge.
So, Judge Kavanaugh, I cited, how many studies did I enter into the record? At least 4 studies that indicate that there is a pattern to your dissents. And your pattern is that you do not favor basically regular people.
Well, I wrote one of my most important dissents, Senator, was in United States versus Burwell. That was a criminal case, an in-bank case for a convicted drug distributor. The question was whether he had been sentenced to a 30-year mandatory minimum permissibly. And I, joined by Judge Tatel, who's an appointee of President Clinton, ruled that the jury instructions were flawed. I was in dissent for him because mens rea requirement had been omitted from the jury instructions, and I wrote a very lengthy dissent about that. That is that's one of my most important dissents, and that was on behalf of a criminal defendant.
Judge Kavanaugh, the thing about patterns is that there are exceptions to the pattern. So all of these studies that I cite to, we're not talking about the exceptions to the pattern. We are talking about the existence of a pattern. You know, it bothers me I would expect a judge to follow the law. In fact, I think you started off several times saying that you are how did you describe yourself in terms of following the law? You said several times.
Independent and pro-law.
Pro-law.
Another important decision is a case, I think I wrote the leading opinion, or one of the leading opinions on battered women's syndrome, a case called United States versus Noy, over a dissent of another judge where I reversed a conviction of a woman on the ground that she hadn't been
Judge
able...
Kavanaugh, I hate to continue to interrupt you, but, 30 minutes goes by awfully fast, and there are always exceptions to the pattern. So, yes, you describe yourself as a pro-law judge. Assumes that means that you consider yourself to be someone who follows precedent and the law. But over and over again, your colleagues in the majority criticize you for not following the law or Supreme Court precedent. Where Congress is clear, you miss the plain language. Where the Supreme Court clearly states rules, you ignore them. Let me cite you to some examples where your colleagues actually took the time to criticize your dissents. So in a 2008 case, agri-processor v. NLRB, the majority said your dissent, creates its own rule. Instead of following Supreme Court rules, they said that your dissent abandons the text of the applicable laws altogether. Or in 2011, the majority in a case called Heller 2 held that Washington, D.C. could ban semi-automatic weapons, and the majority wrote an entire appendix to explain why your dissent was wrong and how you misread the Supreme Court. Mr. Chairman, I ask unanimous consent to have the 10-page appendix in Heller 2 entered into the record.
Without objection.
In 2017, and U.S. v. Anthem, the majority sharply criticized your dissent. They said, quote, rather than engage with the record, much less adhere to our standard, the dissent offers a series of bald conclusions and mischaracterizes the court's opinion, end quote. They said that you, the dissenting colleague, applies the law as he wishes it were, not as it currently is. This doesn't sound like such a pro-law judge to me. Now, why do your colleagues go out of their way
Senator,
so often?
if you could begin to wrap up, please, ma'am.
Why do your colleagues go out of their way so often to point out that you aren't following the law or relevant Supreme Court cases?
Senator, I stand by my record. I've been in the majority, the vast majority of the time, 90 to 95% of the time. I've written opinions joined by colleagues of all stripes. I think there have been studies that shown the affiliation of the judges who joined me in majority opinions when there's been a dissent. I stand by my record. I am proud of my record. I have explained thoroughly my decisions in each case. I appreciate your perspective, and I understand the cases you've raised, but my opinions speak for themselves, and I'm very proud of them.
And I
Senator
think all
Crapo.
these studies speak for themselves also. Thank you, Mr. Chairman.
Thank you, Senator. Senator Crapo.
Thank you very much, Mr. Chairman.